Hi, everyone. My name is Sunny Sion Kang. I'm a data privacy attorney and a policy advocate focused on the partnership of law and technology in supporting sustainable innovation. I'm currently senior product and privacy counsel at an AI company based in the Bay Area. And prior to that, I was head of policy at Infer, which is a cryptographic privacy enhancing technology company. On today's topic of cryptographic technologies in the post-Schrems 2 era, I will be presenting as an independent researcher, and I will get into the roadmap of this talk with you. Schrems 2 was a decision in July 2020 that invalidated the privacy shield, and this had a transformative impact on the validity of EU to US data flows. And the focus is often presented in a pretty negative light, such as people saying that the Court of Justice of the European Union, CJEU, took away over 5,300 American companies' transfer mechanisms with the European Economic Area. And indeed, it's really no denying that this decision has launched many companies into a daunting transitionary period where they need to navigate new regulatory guidelines and also reassess their compliance with the GDPR, and also consider new technological safeguards to supplement the contractual safeguards that they might have already had. In the policy world and the private sector alike, the discourse around Schrems 2 currently has the same hefty and often polarizing effect as the GDPR did when it was first coming into effect in 2018. For example, when you're negotiating a data processing agreement back and forth with a customer, companies now may have a heightened interest in how the transfers will be impacted by Schrems 2 and Article 46 of the GDPR. And you might even be asked questions that you never had to consider before in this context, like assessing the entirety of the United States national security legal regime and how they measure up to EU legal standards. But like the GDPR, as time goes on, companies naturally begin to adapt by investing time and resources into understanding the overlapping rights and responsibilities as they break down into more digestible parts. And they're able to understand how they impact their everyday business operations and know how to move forward, which is the hope for Schrems 2 as well. So the purpose of this talk is to discuss how the changes propelled by the new requirements of Post-Schrems 2 would require the cooperation of lawyers in implementing contractual safeguards such as the European Commission's model clauses, as well as engineers in helping supplement any gaps in this with technical safeguards. In particular, this talk will discuss cryptographic privacy-enhancing safeguards, such as secure multi-party computation, which the European Data Protection Board specifically recommended in its recent guidance. So on this call, we will cover the context of the Schrems 2 decision and the resulting EDPB guidance on supplementary measures, which provides a lot of technical details into how the European Data Protection Board expects companies to supplement any gaps that might not be able to be fulfilled by standard contractual clauses. I also will explain in plain terms the recommendation for split or multi-party processing, which is also referred to as secure multi-party computation, or MPC, and the significance of decentralized analytics in the post-Schrems world, where there's a lot of fear about data localization. I will also provide some use cases and the types of data and the nature of processing in which this technical safeguard would be the most appropriate and applicable. And I will end with a broader policy discussion about the benefits and the potential obstacles of privacy-enhancing technologies and what they face in the uptake and the standardization process. Without the privacy shield, the United States no longer has adequacy under Article 45 of the GDPR to receive data flows from the European Union on the basis of legal equivalency. And the Court of Justice's main rationale in overturning the privacy shield was the program's practical limitations as a safeguard against overbroad surveillance programs in the United States. Now, companies must find transfer mechanisms that resolve the policy objective of Schrems 2, which is to strengthen data transfer mechanisms such that EEA individuals are protected from government access to their data under US law. SCCs and BCRs, binding corporate rules, are a commitment between the parties of the transfer to handle personal data according to the pre-approved terms set by the European Commission and other European supervisory authorities, such as DPAs. But as contractual tools, they have limited efficacy as an ex-ante or preventative safeguard against unauthorized data access, use, or leakage. And here's why. Just as companies often fail to honor their privacy policies, contractual safeguards for data transfers are fallible because they sit on paper. Privacy protections stipulated in SCCs and BCRs can't actively mitigate the impact of a security breach or unauthorized access to plain text data. Secondly, as the EDPB and the Court of Justice has mentioned, SCCs and BCRs are in effect private agreements that can't bind US public authorities. As the EDPB stated in their supplementary guidance, because of their contractual nature, SCCs don't bind the public authorities of third countries since they're not party to the contract. And this is why supplementary measures may be necessary to bring up the guarantees of the SCCs to the level that is required under EU law in a particular third country where the laws may have some lack of proportionality when it comes to government access to data. And because of this, there's an emphasis that relying on these contractual tools alone may not be sufficient to satisfy Schrems 2 and GDPR. And the Court of Justice and EDPB state that where doubts remain on the proportionality of the third country's laws on government data access, the validity of SCCs and BCRs will depend on the use of often technical supplementary measures, such as privacy-enhancing technologies, as an additional firewall against potential exposure. So it seems like filling the void of the privacy shield isn't as simple as replacing the self-certification program with SCCs and BCRs. These alternative transfer tools must do their part actively in curbing government overreach for EU data. So in other words, technical measures may make the commitments made in SCCs and BCRs actionable. After the Schrems 2 decision, there were a few months of uncertainty where companies were at notice to consider supplementary measures, but they weren't told yet exactly what constituted them, which is why the EDPB published this guidance on November 2020. Cryptographic privacy-enhancing technologies become most relevant at stages 3 and 4, as you see here, because at this point, you would have assessed the legal issues in the third country, and now you are considering additional safeguards you may need as a bulwark against the potential of public authority access to data. EDPB considers remote access from a third country or data storage in a cloud situated outside of the EEA to be a transfer subject to this assessment. Supplementary measures will come into play if remote access in a third country involves data in the clear or plain text information, because the EDPB considers this to be a scenario that is particularly vulnerable to government access. For example, let's consider you, a US vendor, sends EU customer data to a cloud that is resident in the United States. Even if the key management rests on you, the cloud provider may technically have access to the underlying EU data if compelled by a government access request. So if you are transferring data that may be of interest from a national security or a foreign intelligence perspective, cryptographic and decentralized safeguards may be necessary. And this might be necessary to keep the cryptographic keys within the EEA, such as by way of bring your own key or BYOK functionality for EU customers to have sole control of their decryption keys, or by the third pillar of encryption and processing, in addition to encryption at rest and in transit, or decentralized computing that keeps data resident at each data source, like secure multi-party computation, which we'll get more into. Among the examples of technical safeguards that the EDPB mentions are pseudonymization, encryption in transit, protected hosting service provider and recipient, but a lot of questions remain on the more esoteric use case 5, which is split or multi-party processing. So the EDPB describes split or multi-party processing as when the data exporter wishes to process data with people across different jurisdictions without disclosing the content of the data to them. And to do this, they would split up the data and give them parts of it in a way that can't be reconstructed by any one of them individually in whole or in part. This process, simply put, describes MPC, or secure multi-party computation, which is a cryptographic privacy-enhancing technology that can prevent the transfer of plain text personal information to a jurisdiction which could potentially have inadequate protections for privacy and fundamental rights. In non-technical terms, MPC enables multiple parties to securely compute on a shared data set without seeing any underlying personal information held by the other participants. And it does so by transforming this personal data into random auxiliary numbers that can be put together to securely run functions across multiple data sources, but reveal nothing in isolation. The World Economic Forum has a white paper on financial information sharing that mentions MPC, as well as the UN handbook on privacy preserving techniques. And these types of publications also provide a great example of additive secret sharing via MPC, which illustrates an example of how this works in practice. So for example, parties may be interested in calculating an average of each other's salary without wanting to reveal how much they individually make. So we might want to break apart their salary number into random additive shares that mean nothing in isolation. So let's say, for example, someone makes 100K. You would break that 3 ways into any random numbers. Let's go with negative 50,000, positive 3, and positive 149,997. And you each share these random values with the other parties, and they give you their random shares back. And then you compute the aggregate average for the answer. And in this way, you know their average salary amongst everyone. So you know the output without seeing the inputs, which is the individual salaries, which is highly confidential and private to people. Essentially, this means that you just perform the function with multiple people without sharing or proliferating any underlying personal information. So the parties only see the output of the function and not the private inputs. So no personal data is exposed or transferred. And after each computation, you can minimize any risk by deleting these random auxiliary numbers, rendering them virtually impossible to intercept or try to re-identify. This technique is significant because it curbs the unnecessary collection, sharing, and retention of personal data, and overcomes the vulnerabilities of mainstream anonymization techniques, which can subject individuals to the unforeseen risks of third-party data access. Preventing unnecessary exposure of data is now a guiding principle to cross-border data transfers after Schrems 2. And this is also critical for systemic accountability and data protection compliance. Using cryptographic techniques is valuable because it essentially allows you to make more use of the data whilst moving it around less. This minimizes the risk that occurs from transfers to third parties and prevents the multiplication of data security and privacy attack surfaces. The technique also embodies privacy by design, specifically data minimization, and it self-executes these fair information principles like purpose specification and limited storage and retention, and also most importantly, facilitates cross-border computation on sensitive data that may require additional protections against potential public authority access by keeping data resident in the premises of each data source involved in the computation. This is really important to addressing the threat of data localization, which often comes up as part of the Schrems 2 discourse, which could fracture the digital economy and also restrict data flows that are necessary for international trade and cooperation. Some examples are here, such as financial information sharing for detecting anti-money laundering by understanding different transactions across banks, and also diversifying input data for medical AI. So you might be thinking, what's the holdup? Why hasn't this been widely deployed yet? Well, because it's new, there is very little precedent at this point about MPC's commercial application, and companies are reluctant to invest in a new information system without explicit regulatory blessing. And this is hard to get sometimes because regulatory guidelines and privacy regulations are technology neutral and for good reason and principle. We don't want rules to become quickly outpaced by emerging technology. But ironically, this makes the adoption of privacy enhancing technologies very difficult in practice because there's certifiable vagueness about Article 25 of the GDPR and also the best practice guidelines like the EDPB supplementary measures document. Regulators do want these data protection principles to materialize in products, platforms, enterprise tech, and business operations, but there's still a long ways to go before we bridge the lexical gap between lawyers, technologists, and policymakers in a systemic fashion. MPC, while it is a topic that has been written in volumes by technologists, is still a blurb in the legal world in law review articles or regulatory guidelines. As seminal as this EDPB recommendation was for mentioning MPC, it's still a blurb relatively to the complexity of the technology in itself. It acknowledges MPC as a valid supplementary measure, but also doesn't really go into what type of data, what nature of processing, what level of computation, whether linear regression or neural nets, and what industries may be able to justify the potential overheads against the potential benefits. So scalability of cryptographic privacy-enhancing technologies desperately need the partnership of governments with stakeholders in the form of tech sprints, innovation office hours, public education campaigns, publications, and more. So yes, there are challenges ahead, but cryptographic privacy technologies are also increasingly becoming more relevant for EU and US data transfers after Schrems 2. And this could be an opportunity for a watershed moment in MPC and decentralized analytics for the betterment of data protection. So the takeaway is that you should assess the need for it in your routine privacy impact assessments and monitor for developments that may necessitate these decentralized analytics and data resident computation techniques as a valid supplementary measure. And this might be the way that we need to go to move the status quo. Thank you so much for joining me on my talk today, and I look forward to your questions.